And welcome back here to Live Now from Fox. I'm Andrew Kraft as we approach the top of the hour. Almost 7 o'clock here on the West Coast, almost 10 o'clock there in the nation's capital. We do want to move on briefly, if we can, to some more of these top headlines, including some of these immigration-related headlines. It's a live picture, like I said, there at the White House. Our friend and colleague, Bill Malugin, posting about this really consequential ruling today at the Supreme Court. He says that SCOTUS allowing the Trump administration to deport illegal aliens to third-party countries for now. The Trump administration appealed to the Supreme Court after a federal judge in Boston blocked third-party removals and blocked the removal of aliens to South Sudan with several convicted murderers on board, including one with a deportation order since 1999. Bill says this is a big win for the Trump administration for now. So the divided Supreme Court ruled on this 6-3. All three liberals dissented. So this lifts for now a court order requiring they get a chance to challenge the deportations, they being these undocumented migrants who are pending deportation here. So in the meantime, we do want to bring into the conversation immigration attorney Miriam Masumi Daoud. She joins me. Miriam, thanks for being with us here. I guess the key words are for now. What does that mean?
What the Supreme Court did today was essentially pause the injunction that the prior lower court had entered into. And that was essentially, basically the fight is now going forward now in the lower courts, but the Supreme Court has paused that to happen at this time.
So I just want to put up some of this file footage of the Supreme Court. So these migrants from countries including Myanmar, Vietnam, and Cuba, they had been convicted of serious crimes in the United States, and immigration officials have said that they were unable to return them quickly to their home countries. So are they going to their home countries, or are they going to a third country that they've never lived in?
Well, at this point, the Trump administration is trying to deport them to a third country that they've never been to. And, you know, some of these individuals, like you said, have been alleged by the government, have been convicted of crimes, but ultimately federal law and our treaty obligations don't stop at criminal convictions. The U.S. is bound by the Convention Against Torture, which is a treaty that we ratified 3 decades ago. And federal law has essentially said that we must follow that treaty. And it prevents deporting anyone to a country where they could face torture or persecution, no matter their past. So ultimately, it's really about ensuring that we don't send someone to a country that they have no ties to, that they've never been to, and that we follow our existing law, regardless of whether if that's convenient or not.
Yeah, so I remember we covered this mere weeks ago, and this was decided, the High Court, and usually in these emergency basis decisions, they don't kind of go into detail about why they came down the way they did. It's a very brief order like they did today. But this came after immigration officials put 8 people on a plane to South Sudan in May. That federal district court judge in Boston, his name, Brian Murphy, found that violated his court order, giving people a chance to argue they could be in danger of torture if sent away from their home countries, kind of what you were alluding to here. So I have to ask, this is more of a broad question, what is the posture right now with illegal immigration enforcement in the country and vis-a-vis deportation flights? After the ruling, what now can the Trump administration continue doing that they could not?
Well, at this point, they can, per this order, resume third country removals. Prior to this ruling today, it was required that the government provide written notice to individuals facing removal to these third countries in a language that they understand, as well as give them the opportunity to move forward with a credible fear screening. So essentially, that's a process that allows them to say, hey, I'm afraid to go back to this country. My life is in danger and I'll be tortured there. And after going through that process, if the government determines that they've established a credible fear, then they would have to move to reopen their immigration court proceedings. If the government finds that they did not establish a credible fear of return, then it's on that individual to file a motion to reopen their case with an immigration judge within 15 days so that they can move forward with something called a claim for protection under the Convention Against Torture. So that process now is not one that people can move forward on per the Supreme Court order today.
Yeah, this federal district court judge, in his order, said migrants must have a real chance to argue they could be in serious danger of torture if sent to another country. You're an immigration attorney. If you were representing one of these undocumented migrants who was about to get on a deportation flight to a country they've never been to, how do you prove that they could face these really, really terrible conditions in a foreign, far-flung country. How do you prove that?
Well, it first would depend on what country the government is selecting that they move to. You know, you've seen pretty high profile stories of individuals being selected for removals to countries like South Sudan or Libya. And these are areas in the world that are some of the most dangerous, some of the most ridden with conflict. And even our own Department of State says that we should not travel there. So it would first depend on the country. And then after that, as an immigration attorney, I would determine what the country conditions are in that country that would make my particular client a specific target for torture or persecution or harm.
Okay, so we actually, Miriam, have a statement in from the Department of Homeland Security responding to this ruling. I want to put it up here for our viewers. So DHS says this, quote, "Fire up the deportation planes," in response to this ruling. So I'm reading it full here. They say the Supreme Court ruling is a victory for the safety and security of the American people. The Biden administration allowed millions of illegal aliens to flood our country, and now the Trump administration can exercise its undisputed authority to remove these criminal illegal aliens and clean up this national security nightmare. It goes on to say, if these activist judges had their way, aliens who are so uniquely barbaric that their own countries won't take them back, including convicted murderers, child rapists, and drug traffickers, would walk free on American streets. DHS can now execute its lawful authority and remove illegal aliens to a country willing to accept them. Fire up the deportation planes, they say. You know, Miriam, I think it's interesting, and we have to note this. We don't have deportation agreements with every country in the world, do we? It's agreed upon.
No, we don't have deportation agreements with every country in the world, but we also do have established processes that we've honored for decades through immigration policy. Um, Third country removals and deportation is nothing new to this administration or even prior administrations. But for decades, we have had basic procedural framework that is in our laws that essentially require due process for individuals going through third country removal. Nobody here is saying that deportation shouldn't occur. What they're saying is that I need to know where I'm going to be removed to. And if I'm going to be removed to this country, I should have an opportunity to say whether or not I will be tortured or harmed there. And this is, again, something that's in US federal law, and it's also part of the Convention Against Torture Treaty that the United States has been a member of for decades. So ultimately, this really goes down to this is what the law is at this time. And the Supreme Court issued this decision today on an emergency docket, the shadow docket, and their order did not explain their reasoning, which, you know, they remain silent on that, and that's typical for the shadow docket. So we don't know why the Trump administration was able to move forward with the deportations now. So we don't know where the authority is coming from, and ultimately we won't know until the lower courts finish the substantive merits of that case, and we could end up back in the Supreme Court to finally understand why things are the way they are.
Yeah, Justice Sonia Sotomayor wrote, the court's action today, quote, exposes thousands to the risk of torture and death. While we have you, Miriam, we have a few more immigration-related headlines. Got to get our viewers up to speed. There was some movement on the case of Kilmargo Garcia over the weekend here. So I want to read from the Associated Press this. A federal judge in Tennessee plans to order the release of Garcia, whose mistaken deportation to El Salvador has become, of course, a flashpoint in Trump's immigration crackdown while he awaits a federal trial on human smuggling charges. But they report Abrego Garcia is not expected to go free because ICE will likely take him into custody and possibly try to deport him. Now, when this was all announced by Attorney General Pam Bondi, the prospect of his deportation back to El Salvador was operative and alive only after the trial and a conviction was secured here. So it seems like they're expediting what they wanted. They want this trial. They want to prosecute him, but they're saying now that this federal judge said he can be released on bond, ICE is going to deport him anyway. Help us make sense. What is happening here?
Well, I think at this point, what they've said is that ICE has issued a detainer. And usually when an individual is facing criminal charges, the ICE can issue a detainer and seek to take custody of that individual. In some circumstances, the criminal proceeding doesn't even move forward, and the individual moves forward with an immigration proceeding. In some instances, the individual might be able to move forward with their criminal proceeding despite being in ICE custody. In the instant case, they wouldn't be able to immediately remove Mr. Abrego Garcia because he was granted what we call relief under the Convention Against Torture, withholding of removal. And the only way to move forward with his deportation is for the Department of Homeland Security to reopen his removal proceedings and show an immigration judge that he is able to be deported to El Salvador. So this wouldn't mean that he'd be automatically deported. There is still a process that the government would have to go through. If the government is successful in that process by reopening the case in front of a judge, then they could deport him if appeals and other avenues do not work.
Right, just reading more from the Associated Press. The ruling yesterday, U.S. Magistrate Judge Barbara Holmes denied the government's motion to keep Abrego Garcia in detention before his trial. She's scheduled a hearing for Wednesday to discuss the conditions of his release. The U.S. government has already filed a motion to appeal the judge's decision and is asking the judge to stay her impending release order. Abrego Garcia pleaded not guilty June 13th to smuggling charges that his attorneys have characterized as an attempt to justify his mistaken deportation in March to a notorious prison in El Salvador after the fact here. What do you make of that claim by Abrego Garcia's attorneys that ipso facto, Pam Bondi, the DOJ, is essentially trying to bring about some type of rationale to charge him to cover for this mistaken deportation? Is there anything to that?
Well, I can't say for certain what the real motivation behind that is, but
Okay.
ultimately the fact that he has been returned to the United States is critical, particularly because it would allow the government to move forward in their case the right way. The right way meaning that if they were to move forward with his removal, that would require them to, again, go in front of an immigration judge and put forward evidence that he should be deported to El Salvador. And that's something that really should have happened to begin with, which was also something that you saw when the government attorney for the administration admitted in a court filing that they removed him by mistake. And that mistake was not going to a court and reopening the case and showing why he should be deported. So ultimately, again, I can't speak to why he was brought back. I can't speak to the allegations against him, but I do think it allows Mr. Abrego Garcia to move forward with procedural safeguards in his case and allows the government to move forward with their case as well. So.
Lastly, Miriam, I thought this was really interesting that came out today via the Cato Institute. We've been talking so much here on LiveNOW about the illegal and immigration enforcement actions that have been taking place, and of course the backlash in response to those via these anti-ICE demonstrations taking place in cities nationwide. And I think this is really interesting. Just wanted to get your thoughts on it. The Cato Institute has this. Our friend and colleague there, Philip Wegman at Real Clear Politics, posted it. 65% of people taken by ICE had no convictions. 93% had no violent convictions. So Cato says this: new non-public data from ICE indicates the government is primarily detaining individuals with no criminal convictions of any kind. Also, among those with criminal convictions, they're overwhelmingly not the violent offenses that ICE continuously uses to justify its deportation agenda. Cato writes, ICE has shared this data with people outside the agency who shared the numbers with the Cato Institute. That's how the Cato Institute got it. They say, as of June 14th, ICE had booked into detention 204,297 individuals. Of those bookings, 65% had no criminal convictions. Your thoughts?
Well, to me, at this point, based on what we've been seeing in the immigration community, that could be accurate. We're seeing enforcement tactics that have not happened in the many years that I've been practicing immigration law. I've been an immigration lawyer for 15 years, and we are seeing ICE take people into custody at locations that, again, per their prior policy and priority guidelines, they were not doing. They're taking people after immigration court hearings. We have heard stories of individuals being detained outside of their place of employment, their homes, schools. And so it's clear at this point that the administration wants to meet certain quotas. And if a person has a removal order, regardless of their background, their ties to this country, their length of residency in this country, they are somebody that is a priority for removal. And you're really witnessing that with the increased enforcement.
So Cato also says most convictions, 53%, fell into three main categories: immigration related, traffic related, or nonviolent vice crimes. So I thought that was interesting there. And this is something I've been kind of grappling with. If you are here illegally, you're undocumented, but you have the proper documentation, if you're in the Trump administration or DHS, ICE, what have you, does it matter right now?
Well, I think it comes down to resources first. For a long time, the administration now, as well as prior administration, simply didn't have the resources to remove the 11 million, if not more, undocumented individuals in this country. So, what they've relied upon historically are priorities, and there are different levels of priorities: individuals who are threats to national security and public safety, then followed by individuals with criminal histories that may not rise to serious levels, but rise to a level enough where it warrants removing them from the United States. And then there's a large majority of individuals who just don't fall into either of those categories. And I recognize that we have immigration laws in place, but the system itself is also, in my opinion, created in a way to be very punitive to individuals who otherwise have been here, who are law-abiding, paid their taxes, who have resided in this country for many years, who have U.S. citizen family members, children, who've contributed to our society. So although the law is what the law is, it doesn't necessarily mean that it's always the right way. So,
All right, Miriam, we're going to have to leave it at that. Thanks for going along with us. There was a lot to get to. We do appreciate it. We'll talk soon.